resources around social care. So you will have just had a notification that this is being live streamed. And again, it's all about trying to make it a little bit more accessible for people. So we are absolutely delighted with this event that we've managed to pull together, and I will do some thanks in a moment, but we've got two fantastic speakers, and we also have people supporting us in the breakout rooms, which we'll do later. So I just wanted to give a big shout out to everybody who has volunteered. I hope you can all still see my screen. I think it's done something funny. Yeah, okay, great. So we are going to just kicking off now, and I'll go through the agenda shortly, but if you've got any questions or you've got any thoughts, then please do make sure that you keep the chat very vibrant. We want to make sure that people are talking about the event and getting involved. Also, you can share it on their social media, but I just ask that people put yourselves on mute. We will also be monitoring that, but because we are doing breakout rooms in the way that we're doing things, we are having to do the whole manual side of meeting people. So if I just do a little bit of an overview. So we're going to be looking at the government's current open consultation, which is looking at the changes to the Mental Capacity Act, Code of Practice, and the implementation of the LPS. And we want to get people's views and opinions on what needs to change and what should stay the same. And the whole idea of this is we want to try and get your views out there to eventually do a joint consultation response, which we've done before, and we will get as many people's views as possible in the breakout rooms later, the second half of this event, and we are then going to put those together and do a submission. Really sorry if you can hear my printer in the background, that will stop in a minute. So I would really encourage you after the talks at the start to stay on to the breakout rooms. We will have a break in between, but the whole aim of putting this together is to try and get your views on the changes in whichever form you want to give them. If you prefer to write in the chat in your breakout room later, or you want to vocalize that in the discussions during the breakout rooms, then please do that, because we really want to get as much of your opinions from wherever you are on the spectrum of social care provision, or being supported by somebody who works in social care or working in social care. Then please do give your views, because they're really important to us to get things, get your perspective. So thank you to Alex Ruck-Keene QC and Tim Spencer-Lane, who you'll hear from shortly, and also to Bonnie Venter. Sorry for calling you out there, Bonnie, but she'll be helping us with one of the breakout rooms, and she's also a PhD, a researcher at Bristol University, and doing some great work there. So along with myself and a few of my other colleagues at Coproduce Care, we will be helping to field conversations and questions and ideas around the Code of Practice there in the breakout rooms. So a bit of background, very shortly, provided by me, because I do want to get on to both Alex and Tim. But the consultation for the draft Code of Practice for the Mental Capacity Act and the LPS was officially launched in on the 17th of March this year. And you did have until the 7th of July to reply. They've extended that by a week. So it's the 14th of July. And that's when you can reply to the consultation. And we will put a link for anybody who actually does want to put in their own response. We won't be able to cover all of the consultation responses because it's quite lengthy in this event that we're having, but we picked out some which we thought are quite accessible to discuss in this type of forum, but we will signpost you to the other aspects that we haven't covered, which you might want to respond to later on in the consultation. And in the event. So it's a joint consultation by the Department of Health and Social Care and the Ministry of Justice. And the draft code covers the Liberty Protection Safeguards, LPS, which is the replacement for the DOLS, the Deprivation of Liberty Safeguards, as well as the main Mental Capacity Act from 2005. So this Mental Capacity Act Amendment 2019 received the royal assent on the 16th of May 2019, which feels like a long time ago, and it is a few years ago, but it has been a long process. There have been a lot of delays, but finally we're at the position of at least being able to give our views back in this consultation, and hopefully having some more progress on it very, very shortly. They're also it's not just a consultation around the Code of Practice. There's also some questions around regulations that need to be written up around the Act. And they are looking for some type of feedback, not necessarily specifically part of the main feedback that they want, which is on the Code of Practice, but they are also looking for people's views on the regulations, along with a brand new Code of Practice. And if you are looking at replying yourself, then you will have precisely until 11:45 p.m. on the 14th of July to respond to the consultation. And I'm sure one of my colleagues will pop in the link to the consultation. But also, you've had anybody who's joined us via the Eventbrite. We did send out some documents with a long sort of one-pager on some really useful links, as well as some of the pre-reading. If you've managed to do that, then fantastic. So I am just going to go through the agenda, then introduce our speakers. So I've just done a very short introduction. I'm then going to hand over to Tim Spencer-Lane, and he'll be followed by Alex Ruck-Keene QC, who then will be talking through some more detail around the proposed changes. And you'll have an opportunity to ask questions. So it might be useful to pop those in the chat as well, and otherwise to unmute when they come to invite you for questions, and you can ask your question that way. But do please keep them short if you can, because time is precious on this part of the event. We'll then have a short break, and we'll have a video from one of our sponsors, and we'll then go into the breakout rooms. And as I said, it would be really great if you could just stay with us for the breakout room, because that's the main part of the event. So we're going to be joined shortly by Alex Ruck-Keene. Alex is an experienced barrister, writer and educator. His practice is focused on mental capacity and mental health law. He edits and contributes to leading textbooks and many other publications, and is the creator of the website Mental Capacity Law and Policy.org.uk. He is also a visiting professor at King's College London and visiting senior lecturer at the Institute of Psychiatry. Sorry, can we have someone muted? Thank you. He spent 2016 on secondment to the Law Commission as a consultant to their mental capacity and deprivation of liberty project, and throughout 2018 was legal advisor to the independent review of the Mental Health Act 1983. He is the specialist advisor to the Joint Committee on Human Rights for their inquiry into human rights in the care setting. So a huge thank you to Alex. Also, he's been very supportive to us before and has done a podcast pre-COVID days, which you can watch on our YouTube channel. And we have lots of discussions on there. So do log on and subscribe, and has recently become a QC. So huge congratulations there as well. And I would also signpost you to his website, which I just mentioned, and I'll pop into the chat as well, because that's really informative, lots of accessible information, some videos as well. So very much recommend going and referring to that. Then we're going to be, just after me now, joined by Tim Spencer-Lane. So Tim is a lawyer who specialises in mental capacity, mental health and social care law. At the Law Commission, he was responsible for the reviews of the deprivation of liberty safeguards, regulation of health and care professionals and adult social care. He now works for the government legal department, the Department of Health and Social Care, where he advises on mental capacity and mental health law. He is the author of the Care Act Manual, the third edition in 2019, and general editor of the Encyclopedia of Social Services and Childcare Law, and contributes to Cross on Local Government Law, which is a definitive narrative text on local government law. He is the legal editor at Community Care Inform for adults and a senior lecturer at Kingston University, where he teaches on the best interest assessor and adult safeguarding courses. And just another really short signpost to Tim's work. If you do join Community Care, their newsletter, or on social media, he does some really good articles on there as well. And on his LinkedIn, I'm always following him and re-sharing his work that he does there, just to inform people of what changes have been happening. So I'm going to finish off sharing and invite my speakers. My first one is going to be Tim, sorry, and I think Tim, you're going to share some slides as well. So hopefully I've stopped sharing, and then I can, great.
Brilliant, thanks Sophie, thanks for that very interesting introduction. Good morning, everyone, and welcome to the session today. My name's Tim Spencer-Lane. My job today is a very simple one. I'm going to sort of spend half an hour with you trying to summarize the main provisions of the Code of Practice as they relate to the LPS. And then Alex is going to come in after that and say lots of interesting things. Mine's going to be a bit bland, I'm afraid. So you know, just hold off a little bit until Alex gets going and everything will become interesting. Anyway, let me get my defense in early. It's really hard to summarize even just the LPS parts of the code in half an hour. So what I've tried to do is just cherry pick the main things, the things that I think are of most interest. But there may well be other things that you're interested in, that you want to think about, you want to discuss. And I'm sure that's absolutely fine, but I'm going to try to stick to the what I see as being the main parts of it. Anyway, the main thing that you're going to be discussing today is the draft Code of Practice. So just as a sort of introduction to it, it's probably quite important to make the very obvious point that the code covers both the main Mental Capacity Act, for want of a better word, as well as the liberty protection safeguards, which is great in terms of making sure, hopefully, that the liberty protection safeguards are directly hardwired into the empowering principles of the Mental Capacity Act. The downside, of course, is that it's a whopper. It's a huge document, over 500 pages long, which means that it will be extremely difficult to, in portability terms, to carry it in your rucksacks or your briefcases. But generally speaking, I think it's quite a positive move that it's all been amalgamated into one document. Also important just to reflect, I think, on what the code is there for, what's its legal status. And of course, you know, it's not a part of the formal law in the sense that there is no legal duty to comply with the code. And judges tend to describe it as being guidance rather than instruction. But, and there's an important caveat to that, if you're a professional or you're a paid worker, you should follow the code, and you can only depart from the code if you have very good reasons to do so, or cogent reasons, as the courts sometimes refer to them. So the code is, in other words, a very important document. And of course, here is the link to the consultation page. And as Sophie rightly recognized, there has been an extension to the final date for responses. So it's now the 14th of July. And part of my sales pitch here today is to encourage you to contribute not just to Coproduce's response, but also if you want to do your own response as well, that can be just as helpful to civil servants in terms of informing them. So I do want to encourage as many of you as possible to contribute to responses or even do your own response if you like. Here is the latest timetable for the introduction of the LPS. As you can see, there is no start date yet announced. So the government's said that it's going to think about that when it looks at the consultation responses and announce a start date at some point then. But you can see we're currently in consultation phase. The government has rather generously given themselves between the summer and the winter next year to consider the consultation responses and do lots of other things, including put together draft the final regulations, the final code, lay things in Parliament, etc. So there are a lot of legal things that need to happen between winter 2023 and the start date. So my hunch on all of this, and it's no more than a hunch, is that it would be legally impossible to implement the LPS before October 2023. That would be the earliest possible date. But obviously we haven't got a start date yet, but that would be my prediction in terms of the implementation. Anyway, let's get on to look at the nitty-gritty of the Code of Practice itself. And chapter 12 is probably the nittiest and grittiest of all the chapters. We could probably spend the whole day talking about chapter 12, to be honest. It's all about the meaning of deprivation of liberty. In other words, it's the government's view of how Cheshire West, the very controversial decision of the Supreme Court, should be interpreted going forward under the LPS. Now, there's a lot in chapter 12. So again, this is just real headline stuff. What the chapter does essentially is that it goes through the two limbs of the acid test to try and set out in a little bit more detail what the government believes the interpretation of the acid test should be. So, for example, we have an opening section which looks at the meaning of freedom to leave, which sets out quite clearly that in the government's view, the way you should interpret that is that freedom to leave means freedom to leave permanently, to go off and live with whoever the person wants to live with. There's then a discussion around constant supervision and constant control. I mean, the code obviously recognizes that there is a lot of overlap between the two concepts, but ultimately it has to deal with them separately. In terms of supervision and constant supervision, one of the most interesting focuses of that section is the idea of the person not being left alone for significant periods of the day. So the code is suggesting, particularly in care home scenarios, that that may be one of the key questions that needs to be asked. Also, when it comes to control, how the code defines that is the person not being able to choose to do the things that they want to do. So quite a lot of emphasis there in the code in terms of enabling the person to do what they want to do. There's also an interesting section of chapter 12, which looks at domestic deprivations of liberty in private setting, in the family home. And it suggests that you're going to need to nuance the acid test in those sorts of settings. For example, freedom to leave, it may not make sense to think about freedom to leave permanently. It may make more sense to think about freedom to leave in terms of being able to go out on a temporary basis. The code also suggests that the test of capacity in some domestic situations may well be lower than it would otherwise be in a care home or a hospital, because the relevant information will be much more straightforward in some circumstances. The chapter finishes by looking at two other concepts when it comes to the meaning of deprivation of liberty. The first of which is the concept of advance consent. So it sets out the notion that a person who has capacity can consent in advance to arrangements, to restrictions, which if then put into place would mean that the person is not being deprived of their liberty, because in effect, they are consenting to the arrangements. Now, as we know, advanced consent has been used quite frequently, particularly in hospices and end-of-life care settings, where people will consent in advance to a care plan, which is normally implemented within a few days. And if implemented, if restrictions are then placed on the person, generally speaking, the person won't be considered to be deprived of their liberty. What's interesting about the code is that it does say that in principle, the concept of advanced consent can be extended to other settings, including, for example, hospital settings or psychiatric hospitals, informal admission to psychiatric hospitals, depending on the circumstances of the case. Finally, the chapter deals with what is often referred to as the Ferreira carve-out. So this is the idea from the Maria Ferreira case that deprivation of liberty will not arise if you're providing medical treatment for physical disorder, and that treatment is materially the same as that being provided to a person without a mental disorder. So the Ferreira case, as I'm sure many of you are aware, involved someone who was in an intensive care unit. And that's really what the court was talking about. What the code emphasizes, however, is that that principle can be applied, one, to any form of medical treatment for physical disorder, and two, any setting. It's not limited even to a hospital. If the circumstances did arise outside a hospital, for example, the Code of Practice sets out that the carve-out would apply there too. Anyway, moving on from that, chapter 13 of the code gives quite an interesting overview of how LPS as a process should work. Part of what it deals with is the notion of referrals. And what it tries to emphasize here, quite rightly in my view, is that the LPS should always be mainstreamed. It should always be carried out alongside existing health and social care systems or assessments or reviews. So it's not seen as something separate. Secondly, and again, a very important message, I think, which is that responsible bodies in particular should be thinking about ensuring that all health and social care professionals, staff members, care providers should always be aware of what deprivation of liberty means when there is a potential for deprivation of liberty, and importantly, what action to take when they think that deprivation of liberty may arise. And part of that will involve developing appropriate referral systems. And there's an expectation set by the code that if a referral is made and accepted, the person making the referral should be informed of that fact within 5 working days. Anyway, one of the first tasks of the responsible body when it receives a referral is to commission 3 assessments. An assessment of whether the person has capacity to consent to the arrangements, whether the person has a mental disorder, and whether the arrangements are necessary and proportionate. So one of the important things that the draft regulations set out is who the government intends should carry out these 3 assessments. So as you can see from this slide, what the government is setting out for consultation is a position whereby the capacity assessment and the necessary and proportionate assessment can only be carried out by a registered doctor, nurse, OT, social worker, psychologist, or speech and language therapist. When it comes to the medical assessment, that's restricted to doctors or registered psychologists. So that's the government's starting point in terms of who should carry out the assessments. In terms of how assessments should be carried out, mainly this is dealt with in chapter 16, but the code puts down an important marker, which is that the assessment process which it defines as being the period of time from the referral to a final decision being made about the authorization, that period should not exceed 21 days. So in other words, what the code is trying to do is replicate the existing legislative requirement that exists in England, at least, under the DOLS. It also sets out that there should be no fewer than 2 professionals involved in carrying out the 3 assessments. So you can't, for example, have a single doctor carrying out all 3 assessments. Instead, what you'd be doing is, for example, having a social worker maybe carrying out the capacity assessment and the necessary and proportionate assessment, and a doctor maybe coming in to provide the medical assessment, either in real time or maybe through a previous assessment. The code also, interestingly, suggests that the professionals who are carrying out the assessments, that there should be a degree of independence from each other. Now, the code doesn't quite define what independence means, but what it does do is set out a number of principles that the responsible body would need to consider when allocating assessors. For example, it says that the assessors shouldn't be members of the same clinical team or shouldn't be in a direct managerial relationship. One of the most important aspects of the liberty protection safeguards is a reconfiguration of the role of the Court of Protection. So the Court of Protection, in principle, no longer gives an authorization in the first place, as it currently does, for example, for young people or in domestic settings. So the code reflects that policy in Chapter 7. So except in rare circumstances, you shouldn't be going to the Court of Protection for an authorization. However, there will be cases where you're already in court because, for example, you need to take the case to court because it involves serious medical treatment or restricting contact with family members. And as a result of that, issues around deprivation of liberty may arise. What the code says is that deprivation of liberty should be considered as a standalone decision. So it's for the Court of Protection to make the best interest decision regarding, for example, the medical treatment or the family contact, but it's still down to the responsible body to make the deprivation of liberty decision. There is a caveat to that, which is that in rare cases, if the 2 issues are so closely intertwined, as the code puts it, the court can consider the issues together. And in this respect, the code gives the example of tenancy agreements being an issue where the court should consider the 2 issues together. So moving on to the next stage of the process, which is the pre-authorization review. So one of the new things in the liberty protection safeguards is the introduction of a new role, the approved mental capacity professional, who oversees cases, particularly when the person is objecting or where the person is being detained in an independent hospital. What the regulation sets out is the government's intention about who can carry out this role. So as you can see, when it comes to the professions who can carry out this role, an AMCP would need to be a nurse, social worker, psychologist, speech and language therapist, or an OT. But there are also additional requirements, including the expectation that the professional has 2 years post-qualifying experience. There are various expectations around their skills and knowledge levels, plus an expectation that they have completed specialist training. So we know from the consultation documents that there will be a shorter conversion course for existing BIAs, which will run before LPS is implemented. But going into the future, there will be a longer course, which will be based in higher education institutions. Plus, there's also stuff around criminal record checks and also the need to have appropriate indemnity. So chapter 18 is the main chapter that deals with the role of the AMCP, and it emphasizes that mainly the AMCP will be responding to cases that they have a duty to consider cases where the person is objecting to the arrangements or in independent hospital cases. But the responsible body also has a power to make a referral in other cases as well. And as long as the AMCP agrees, then the AMCP can then consider that case. Now, what the code does here is that it tries to limit responsible body's discretion in this regard. So the code suggests that a responsible body should only be making a referral outside of the statutory criteria if, first of all, high levels of restraint are being used, or in borderline cases. And by borderline cases, it means where it's not clear if the person's objecting or not, or it's not clear whether this is maybe a Mental Health Act case or not. The code also sets out an important message that responsible bodies should not be trying to cherry pick their preferred AMCPs, and they shouldn't be referring cases directly to an individual AMCP. Instead, in England at least, the expectation is that there should be some sort of central hub or team that considers whether the referral criteria are met, or allocates cases to individual AMCPs. So that team, the expectation seems to be that the team is organised by the local authority as the approving body for AMCPs, but also responsible bodies can set up their own teams if they want to do that. As long as the local authority agrees, then they can go ahead and set up their own team. For example, it might be that a hospital wants to set up an AMCP team in order to consider referrals much more speedily than normal. If so, they can go ahead and do that with the agreement of the local authority. Something's going on in Wales, however, because we get this very odd statement that's repeated, I think about 4 times in the code, which is that in Wales, arrangements for AMCPs will be decided locally. So we don't quite know what that means, but it does seem that the Welsh government maybe has something else in mind in terms of how AMCPs should be organised. So in terms of the role of the AMCP, well, they're primarily there to consider if the authorization conditions are met. That's their primary role. And in order to do that, the code sets out that they're going to obviously need to scrutinize the assessments, but importantly, they're also going to need to get hold of other information, including perhaps the person's care and treatment plan or other documents that are relevant to the person's care and treatment. The code also emphasizes that an AMCP cannot have carried out any of the 3 assessments in any case they are reviewing, and their role is slightly more expanded than just considering the authorization conditions. For example, they can also be involved in safeguarding issues about making referrals where there are concerns, making recommendations to commissioning bodies in terms of the care and treatment that's provided to the person, even drafting the authorization record itself and placing conditions upon the authorization. So all of these are sort of seen as being possible roles for the AMCP going forward. Plus, if that wasn't enough, they also get a direct role in reviewing cases as well. So the code sets out the expectation that the AMCP should be carrying out a review of the authorization if the person wasn't objecting when the authorization is given, and then subsequently they start to object to the arrangements. Also, AMCPs in some cases, the code suggests, may give the authorization on behalf of the responsible body as well. But if they do that, they need to be very clear in terms of which decision they are making and which hat they are wearing when making that decision. I want to just spend a few minutes talking about authorization records, which I think are one of the most important aspects of the liberty protection safeguards process. Essentially, this is documenting what arrangements that are being authorized by the responsible body. And I think they're going to be subject to quite a lot of attention going forward. The code sets out very clearly that ultimately this is the responsible body's thing. If there's a challenge to the authorization record, it's the responsible body that's going to be carrying the can. Also, it sets out some interesting guidance in terms of how to draft the arrangements that are being authorized. So it suggests that in some cases you can be quite broad about it. And for example, think about authorizing deprivation of liberty in a care home. Whereas in other cases, particularly if the person is going in and out of different settings, you may need to be much more prescriptive and precise in terms of the arrangements you are actually authorizing. Another aspect of it in terms of how the arrangements are drafted is the idea that you can build in conditions to the arrangements that are specified on the authorization record. For example, you may want to build in stuff around contact arrangements or things about the person's culture or anything else which if wasn't dealt with would mean that the deprivation of liberty just wouldn't be justifiable. And the record has to include a program for reviewing the necessity for the authorization, for example, by specifying clear dates for that. One of the most important policy goals of the LPS has been this idea of portability or passporting of the person when they move between different settings. So this is the idea that an authorization may not necessarily end just because a person's situation changes. So the code sets out what the government intends in terms of portability. So as a general rule, what it's talking about here is that when you give the authorization, any changes in setting that you can reasonably foresee when you give the authorization can be included in the authorization record itself. So in that way, the LPS is portable because it means you don't have to give a new authorization in principle each time the person moves settings. Now, however, of course, if you can't foresee those new settings, then it follows that you will need to think about giving a new authorization, particularly, for example, if the person has an unexpected admission to hospital or something like that. Now, there are limited circumstances, according to the code, where a responsible body could legitimately vary an existing authorization. But the code says that that should be used extremely sparingly. For example, to make very minor changes to the arrangements or to remove the arrangements. What you can't use the variation power to do is to add new settings or new arrangements, because that would undermine the person's Article 5 rights. Also important to recognise that the right to IMCAs and the importance of mental capacity advocates in the liberty protection safeguards. And this is reflected in chapter 10 of the code, which deals generally with the role of IMCAs. So there is a duty to appoint an IMCA if the person can ask for one and they have capacity to do that, as long as there is no appropriate person. And if the person lacks capacity, you have this really weird duty, which is that you have to appoint an IMCA unless this isn't in the person's best interests. What the code sets out is that the government believes it would be extremely rare that an IMCA wouldn't be appointed. And the only example it can give is the example of a person at the end of their life who clearly doesn't want an IMCA and their family don't want an IMCA. In those circumstances, it wouldn't be appropriate to appoint one, but most other circumstances, it would be appropriate. In terms of the role of the IMCA, we have new amendment regulations which set out, and the Code of Practice itself, which sets out that the IMCA should accompany the person during the assessments and consultation. Their functions include writing reports for the responsible body in relation to the proposed arrangements. IMCAs are also encouraged to nudge responsible bodies to make referrals to AMCPs when an AMCP should be considering the case. Plus, they should also be thinking about taking the case to court. We also have a new statutory role known as the appropriate person. The appropriate person is dealt with in chapter 15. And the general rule is that the appropriate person is someone who's not professionally involved in the person's care. So the code sets out the expectation that in most cases, the appropriate person will be a family member or a trusted friend, or even a volunteer or advocate or helper at a day centre. But there's some interesting guidance in terms of when an appointment of an appropriate person wouldn't be appropriate or suitable rather. For example, maybe if they live at distance from the person and only have occasional contact, or they don't really understand the local authority process. So on that basis, we get this lovely line in the Code of Practice that it's not sufficient to know the person well or love them deeply. The focus should be on the quality of the support and the representation that the appropriate person can provide. And the code also deals with existing case law in terms of whether you can appoint an appropriate person who supports the arrangements or even who's implementing the arrangements in a family setting, for example. And it suggests that caution should be exercised before making those sorts of appointments. Final area I wanted to cover is very quickly is the role of the responsible body. So in terms of who the responsible body is, the general rule is that in England, at least, if you're in an NHS hospital, it's the trust for that hospital. If you're in an independent hospital, then it's a local authority that's the responsible body. If you're not in a hospital and you're getting continuing health care, then it's the CCG, or going forward, the Integrated Care Board, who would be the responsible body, and otherwise it's a local authority. So chapter 14 of the code tries to highlight some tricky issues around identifying the responsible body, particularly the meaning of the word mainly. So a lot of the time, identifying the responsible body will be a matter of identifying where they are mainly, because they may well be moving between different settings. So the code suggests that your focus in those sorts of cases needs to be on time considerations. It also talks about hospices and says in most cases a hospice is an independent hospital and therefore the responsible body would be a local authority. There's also guidance on NHS continuing health care. So it basically says a bit of a gloss on the statutory criteria here, but it says basically if you're assessed as being eligible, in those cases, the CCG/ICB will be the responsible body. And finally, we have a principle which I wasn't aware of called the no wrong door principle, which basically means that if a referral is made to the wrong body, then it's down to that body to identify the correct responsible body and then inform the person making the referral that that is happening. Anyway, chapter 13 also deals with the role of the responsible body and lists a number of things which are set out in the statute in terms of what they should be doing. For example, publishing information, combining LPS with mainstream processes, making authorization decisions, etc. And finally, what I wanted to do before I hand over to Alex is just to make a plea with you that obviously the LPS bits are really important. It's really important for us to focus on them today. But please don't forget that the LPS does not exist in a vacuum. And indeed, it's only one aspect of the Mental Capacity Act as a whole. So please also remember the rest of the code, because there's lots of interesting stuff in the consultation. And also it's important to remember that we need to get the Mental Capacity Act bit right in order for the LPS to work. They should be seen as being the same thing. So it's very important to remember the rest of the code. And as I say, there is a lot of interesting stuff in there, including stuff on executive capacity, fluctuating capacity, remote assessments, best interest decision-making, etc., etc. So please don't forget the rest of the code of practice. Anyway, with that, I shall pass over to Alex, who I think is going to deal with some consultation issues.
Thank you so much, Tim. That was really informative and super helpful, and I hope everyone else is finding it useful as well. I do realise that my slides weren't working properly at the beginning, so I hope everything did make sense to anyone, but any queries do pop in the chat, and I think we'll just head over to Alex.
Brilliant. Thank you so much. Thank you so much for the invitation, Sophie, and thanks for all hard work behind the scenes as well, including in particular Ella, who I know has been racing around like a headless chicken, sorting this all out. And thank you very much indeed to Tim for giving an incredibly expert overview. He's my former boss at the Law Commission, and it's always a joy to hear him in action. I need to start with an apology. My children have managed to give me something which isn't COVID, but is making me feel quite peculiar. I'm drugged up to the eyeballs with prescription medication. So if some of this is a bit gibbery, apologies. What I'm not going to do is talk for as long as Tim did, not least because I want to make sure we leave some time for questions and answers, because both Tim and I are going to have to leave at the end of this slot. And so if there are questions, and I can already see there's some really interesting questions in the chat function. But what I wanted to do was flag up a few points which have really been raised with me in the course of the consultation period. Either by people emailing me, or I lurk in the background in various different network meetings in different both healthcare and social care. And so just flagging up a few things which I wanted to draw to your attention. I would also say I'm allegedly on sabbatical. I am not supposed to be doing this sort of thing, but Sophie's extremely persuasive. And because I'm on sabbatical, I'm trying not to do too much of this sort of thing. My conscience makes me think I've got to help here. And so I have recorded some videos with frequently asked questions, which you can find via my website. So some of what I'm saying now is a kind of a condensed version of some of the things which appear there. So the first thing just to say is you will see, if you've read it already, the code is littered with typos at the moment, which is actually quite irritating for lots of people. It's irritating for the civil servants, it's irritating for everybody else. Please, please, please don't use your consultation response to point out typos. That's just not what DHSC, MOJ, DFE are wanting. They want response in the consultation response to be focusing on substance. They've got the lps.cop@dhsc.gov.uk email address, which I know Sophie can put into the chat function. That's where they want typos to be flagged, typos and missing cross references. So let's just sort of get that out of the way. The other thing I wanted just to spend a couple more minutes thinking about is the status, purpose, scope and limits of a code. I mean, Tim's very rightly said, the code is not law in the sense that it is not statute, nor is it statute as interpreted by the courts. What it is something laid before Parliament, so it's got statutory force. It's not just DHSC, for instance, is off-the-cuff views of things. It's been laid before Parliament, so Parliament's had a chance to think about it. Guidance, amplifying the Act, which you have to have regard to. But if there's a punch-up between what the code says and, for instance, what the courts have said, you have to follow what the courts have said. A really good example of that in relation to the current iteration of the code is that the current iteration of the code says you start, if you're thinking about someone's capacity, with do they have something wrong with their mind or brain? And only if that's the case do you go on to think about whether they can make the decision. That's just wrong. Supreme Court in the case of JB says start with can they make the decision. It's only if they can't make the decision you then go on to ask why not. So when the main MCA code is being updated, and I completely echo Tim's plea here, please look at the bits which also deal with the main bits of the MCA, because they're really important and actually apply to far more people than the LPSs are going to apply to. The main bit of the MCA is now being updated, code is being updated to reflect the fact that the courts have said that the previous iteration got it wrong. The tension between what the code might say and what the courts have said is most acute, as Tim I think was alluding to in some ways, in relation to chapter 12, dealing with definition of deprivation of liberty. The courts have laid down the definition. Cheshire West in the Supreme Court, Re-D in the Supreme Court laying down how it applies to 16, 17-year-olds. We've got quite a lot of other case law. To the extent that the code seems to narrow the cohort of people who are considered to be deprived of their liberty, if you follow what the code says rather than what the courts have said, you will be giving rise to a situation where someone is unlawfully deprived of their liberty. And so one of the things which is really important to tease out in the way in which you respond to the code in relation to chapter 12, if you think what the code is saying and what the courts have said about deprivation of liberty don't mesh, please make sure you explain to DHSC, MOJ, why that's the case. I think one other thing just to flag up in relation to the code, and I will talk a little bit more about deprivation of liberty in a minute, but one other thing to flag up in relation to the code is it can't make up the law. It can't generate a legal obligation which doesn't exist, either in the Mental Capacity Act or from somewhere else. That was made really clear in a Supreme Court case from a couple of years ago called NHS Trust and Why, where the Supreme Court was looking at the bit of the code which suggests certain circumstances under which you have to go to court and made it sound like you had to go to court in certain cases, in particular withdrawal of life-sustaining treatment from somebody in a permanent vegetative state. And the Supreme Court says, to the extent that the code was saying there was a legal obligation, you can't get that legal obligation from the code. So it's going to be important in looking at the code, the draft, where it looks like it's imposing legal obligations, you're going to have to think, well, does that really come from the code? Does it come from the Act? Does it come from the courts interpreting the Act? And one last point in relation to the code is there's always a balance to be struck in a code of practice amplify a piece of legislation between setting down high-level principles. These are things which it's really important you have in mind when you are thinking about the Act, and trying to set down operational protocols. And you might think there are different bits of the code which go much more heavily on operational protocols than they do on principles. A really good example is chapter 13 in relation to approved mental capacity professionals, where the Act is actually extremely silent on how approved mental capacity professionals are supposed to be established and how they're supposed to be commissioned and things like that. As Tim said, in the draft code, there's a great deal of emphasis on the creation of AMCP teams in England. Wales is clearly thinking it's potentially taking a different course here. And there's a great deal of discussion of kind of almost very operational matters there. You might have a think, do we really think it's sensible having a code talking about that? One reason for flagging that up is that, of course, if it's a statutory code, it's actually quite difficult to change. We've never been able to change the code relating to the main body of the Mental Capacity Act. It's now 15 years old and is galactically out of date in some ways. But because it's statutory, it's very difficult to change. And so if you've got some bits which talk about establishment of AMCP teams, and we will know that the first time LPS is run for live, we will discover things no one really knew about, Rumsfeld's known unknowns. And if you've got a statutory code setting down things in a lot of detail, is that going to cause potential problems? So you're going to need to think through, does it get the balance quite right there? I said I'd talk a little bit about deprivation of liberty a little bit more. It's clear that the draft code is really trying to tighten up a definition of deprivation of liberty. It can't redefine it, but it's clear that the government is setting down a quite narrow view in certain ways about the concept. And you're going to have to, as I say, think about how does that square with what the courts have said? And also, how does it square with the kind of meta level point that Lady Hale said in Cheshire West, which is we need to err on the side of caution in the context of deprivation of liberty. And you might just want to think about, is there a difference between the message which is given to a care provider, in other words, please refer in the case of a potential deprivation of liberty, and the message which is given to the team within the responsible body, which is deciding, is this actually a deprivation of liberty? And you might think that actually the message you want to be giving to care providers is, if in doubt, refer in, then let the responsible body do the thinking. And you might potentially think that the way the draft code is written at the moment could be suggesting there shouldn't even be referrals in a lot of cases where it might be a bit grey. You might think that's a slightly challenging aspect. The other area you might think, so I keep saying you might think, I'm quite clear, this is a very challenging thing to say in the draft code about the concept of advanced consent. It's completely unchallenging, as far as I can see, uncontroversial in relation to admission to palliative care, hospice care, short-term defined. It becomes very fruity, from my perspective, when you start talking about informal admission to psychiatric hospital. Because the code says, in principle, you could consent in advance. So you could be admitted to mental health hospital to be treated for a mental health crisis. You wouldn't have capacity to consent at that point. Your consent you gave in advance would survive. You would be treated as an informal patient. That's something, wearing my hat as a legal advisor to the Mental Health Act review. Timing on this is quite interesting, by the way. Draft mental health bill is being published any minute now. We had the press release, we don't yet have the draft bill. When the Mental Health Act review was looking at this, we said, we see the logic of being able to sign up and assert your legal capacity in this context, but that's quite brave to have people detained, de facto, as it were, detained, confined in a mental health hospital, there on the basis of their prior consent. The Law Commission had said we could see the logic in this, but it would need to be put down in statute. The government didn't adopt it, but has tried to bring it in through the code. You might want to have to think about how comfortable you are with that. A few more issues. One of them, people have been flagging up in relation to the code, but this is because it's just in the Act. People have woken up and realised, hang on a minute, we're going to have AMCP consideration in relation not just to independent mental health hospitals, but also independent physical health hospitals, which include hospices. So automatic AMCP consideration in relation to all of those hospices, inpatient facilities, which are not NHS hospitals. And there are very, very few. I think there may be as few as 2 NHS inpatient hospices. All the rest are charities considered to be independent hospitals. And people are flagging that up in the code, but that's because the Act says that. And that might be because the Act was amended, the bill was amended at rather high speed as it was going through Parliament to deal with concerns in relation to independent mental health hospitals, without quite twigging that that might also cover independent physical health hospitals and hospices. And that just places a load on AMCPs, which some people might think is isn't quite where we thought we should be going, but that's not something the code can do anything about. The chapter, Tim didn't talk a huge amount about this. I mean, it was an incredibly expert overview of the code, but one point which has been raised a lot with me is in relation to so-called section 4B. So section 4B deals with 3 completely separate things. The first is effectively the bit which is already covered by section 4B as it stands. I am depriving someone of their liberty, I'm getting authorization from the court. Until I get that authorization, I'm allowed to deprive the person of that liberty subject to limited conditions. One of which, and there was a question about vital acts in the chat function, one of which is, I need to carry out a vital act to ensure this person does not suffer a serious deterioration in their condition or carry out life-sustaining treatment. That definition of vital act has been in law since the 1st of April 2009. There's no case law about it. No one seems to have found it difficult to interpret to date. It's very interesting that now it's appearing in the code in more detail. People are looking at it and going, oh, I'm not quite sure what this means. My view is it's actually one of these things, it's much easier to see in practice than it is to talk about in the abstract. So that's the first bit of section 4B, asking the court. The second is what everybody is going to call interim authorization. I'm depriving someone of their liberty. I've referred either to a responsible body because I'm actually different. I'm detaining in a care home, local authority is my responsible body, or I'm both detaining and responsible. I'm an NHS trust. I've referred and we're going through the process of consideration. Again, section 4B says you can deprive someone of their liberty whilst that process is being carried out, subject to limited conditions. There's an interesting bit in the code which says that section 4B is not an ongoing power. I have to say for myself, I found that rather difficult in that context. If what you're needing to do, for instance, is keep someone in a care home subject to arrangements for 21 days, assuming the responsible body is able to get their act together and complete everything within those 21 days, not a statutory time frame, but a clear steer in the code. And those arrangements are make sure the person doesn't leave the care home, keep an eye on them. That is an ongoing state of affairs. So you might want to think about whether the bit in the paragraph which talks about that in relation to section 4B quite captures it accurately. And then the last bit is this person is neither subject to an application to court, nor are they subject to interim authorization, but it's an emergency. And people are wondering about precisely whether the terminology there with all the drafting of the draft code quite captures the clinical, because this was mostly clinical realities of what happens in an emergency. So have a think about that, see whether it covers it. I've done a video, I think my most recent video talks quite a bit about section 4B because I've had so many questions about it. 3 more points and then I will shut up. The first is people really, really hate the chapter of the code relating to the Mental Health Act, Mental Capacity Act interface, but they hate it primarily because they hate the interface. And I'm afraid we're stuck with the interface for the foreseeable future because the government has said we are not going to change it. So there's going to remain this horrible need to navigate between the two. It will, though, pan out differently for NHS hospitals, because NHS hospitals will be both detaining and responsible bodies. And they will have to decide for themselves, is the person in question a mental health patient? And if they are a mental health patient, are they an objecting mental health patient? It's only at that point in general that they're going to be going anywhere near a local authority. Unlike at the moment, where every time an NHS trust is detaining someone, whether that be Mental Health Act or Mental Capacity Act, they have to go to a local authority. So the dividing line is going to remain awful, but will be applied slightly differently in NHS hospitals going forwards. The draft regulations, as Tim says, the government is importantly, I think really importantly, and unusually, it doesn't normally do this, but it's really unusually consulting on the draft regulations accompanying LPS. I think it's very good they're doing that. Tim gave that really useful overview of who it is considered is going to be able to carry out the relevant tasks. Many of you will be thinking, do these regulations actually allow us to do what we want to do? If you've got a very clear push that LPS is as much as possible meant to be about mainstreaming things, if you've got a local authority where, for instance, the majority of the decisions made in relation to assessing and meeting people's needs under the Care Act aren't carried out by, for instance, qualified social workers, all of that would have to be redone by somebody who meets the criteria under the LPS regulations. So you might think that rather goes against the mainstreaming idea. There are arguments either way on this, but you will need to think about this if you've got an organisation where you're thinking, how am I going to plan workforce on this? And then the very last point is about scenarios, because you'll see through the code of practice, there are lots of scenarios. I do just want to make sure that you know there's a different way of doing this, or there's a potential for a different way of doing this. Northern Ireland passed a Mental Capacity Act in 2016. It's not fully implemented yet. When it's fully implemented, it's going to be a fascinating piece of legislation, fully fusing mental health and mental capacity legislation. At the moment, they've only got their DOLS equivalent in. The Northern Irish decided they would have a statutory code with no scenarios and a non-statutory book of scenarios. You might think, and I have to say, this is not a you might think as far as I'm concerned, I am absolutely convinced it's a much better idea to do that, because it means you can have a lot more detail in the scenarios. They could be more nuanced. They don't all end in cuddles, because if you're having a very limited number of scenarios, you tend to have ones which sound like they've got nice outcomes. And actually, we know quite often the proper operation of the Mental Capacity Act doesn't result in a nice outcome. Bit of Greek philosophy for a second. Remember, autonomy comes actually from the Greek tragedies, the classical Greek tragedies, where autonomy was about the person's ability to choose how they died. So it wasn't all about cuddles. So if you have a more nuanced book of scenarios, you can have ones which look much grittier. The other thing you can have is scenarios which are much easier to change because they're not statutory. And if we get case law changing, it's much easier to change them. The counter argument is, if people just read the code and it doesn't have scenarios, it may not bring the code to life. But if in reality, we're looking at a 500-page code, it's not a document which is going to leap off the page. So you might want to think about operationally, how useful do you think it would be to have scenarios which actually get down in the weeds? And in relation to scenarios, my very last point is, if you don't like the scenarios, please bear in mind, these were scenarios drawn up by civil servants doing their best. If you don't feed them material which actually responds to the situations you're dealing with, they have nothing to go on. So please feed back gritty operational stuff, because that's what they need in order to make sure you've got a code which actually does what you need. So I think that's all I was going to say. What I will do is I will just put the into the chat function, I'll put the Northern Ireland Book of Scenarios, just in case people are interested in that. Otherwise, we've got some questions, and I maybe just best if Tim picks up the first ones, because they were, I think, directed to him.
Yeah, if that's okay, Tim. I'm conscious. If you can't see, I can read that one out. So it's asking, can you explain why NHS trusts or other NHS responsible bodies require the agreement of the local authority before setting up an AMCP team?
Well, the code doesn't explain that, but I assume the policy thinking behind it is to have some sort of ownership locally of AMCPs, and as the local authorities there to approve AMCPs and to ensure a sufficient supply of AMCPs in the area. In a sense, they're allocated the task of trying to make sure that the local arrangements are rational, and that's why they get sort of given the task of determining how the team works, where other teams can be set up, etc. Because if they feared that it may not be appropriate, maybe for one responsible body to set up their own team, they can have some sort of veto over that, I guess.
Okay, thanks for that, Tim. There is another, I think, shortish question. I can find it. Will care managers no longer be able to make a referral?
So there's no formal referral process, as it were. So it's a bit like the Mental Health Act. It just assumes that referrals are made, they arise. So in effect, anyone can make a referral. It's not like the DOLS where you have official referral makers. It's anyone can make a referral, but it's down to the responsible body to put in place processes to manage that. Now, of course, what's gone from the LPS is the idea of a care home manager process. So where you have a sort of different process and referral process in relation to care home arrangements. And importantly, I've forgot to cover this, the code is asking whether the government's decision not to implement that is the right one or not, which is another sort of aspect of the LPS you may want to respond to, as Alex would say.
Yes, absolutely. That's really helpful. And we have a whole, one of our breakout rooms is going to look at scenarios. So hopefully if anyone's interested in putting scenarios forward, we can discuss that in that breakout room. Really interesting that Alex brought that out. And we'll talk about that question as well. You mentioned about care home managers, Tim, as well, in one of the breakout rooms. Another one, I don't know whether, Alex, there's a few coming up. I didn't know whether you wanted to just pick some of the questions or whether I should just go through them. What would be easiest? I'm conscious of time.
Can I just pick up very quickly the separate guidance for those working with 16, 17-year-olds? I mean, I think this is, there's a chapter in the code which deals with it. I think it's one that people need to look at very, very carefully. I think it's also really obviously the case that people are on a, I don't want to say vertical, but a very steep learning curve in relation to the application of mental capacity Act to 16, 17-year-olds. Part of me is mildly grumpy because there's no change in the law here. The Mental Capacity Act has always applied to 16, 17-year-olds, but I think it's fair to say that wasn't always entirely understood. And it's in part because of the courts starting to get involved here. For instance, the Supreme Court in the Reedy case talking about confinement and 16, 17-year-olds, that we've got this much greater attention. And then LPS is going to put statutory attention on this in terms of confinement, which then has, as it were, blowback upstream in relation to just general decision making in relation to 16, 17-year-olds. Whether separate guidance is needed, I don't know. I know Khalil Khan has done a brilliant bit of work in the Northwest in terms of the 16, 17-year-olds and the Mental Capacity Act, and particularly in the health setting. And he's been leading on work, and there's a conference he's organising with Sussex CCG, or by the time it comes around, ICB, in October about mental capacity at 16, 17-year-olds. So I think it's probably more a question of less statutory guidance, more people just banging the drum in that regard. I would also just flag that there is a judgment which is out from Senior Judge Hilda. Weirdly, it hasn't appeared on Bailey, which is the case law database yet, but it's out, talking about her concerns that she's seen in relation to applications being made to authorise deprivations of liberty of 16, 17-year-olds being sent into court. And the thing she's most concerned about is where applications have been sent in on the basis of these are entirely suitable for the streamlined paper-based process because there's nothing to see here, please move on. And she's gone, you what? Is this considered normal practice in relation to 16, 17-year-olds in transition? I mean, she's just been really alarmed. So that judgment is quite an interesting kind of wake-up call in terms of how the courts are thinking about what local authorities might be doing as a matter of routine. And there might need to be some quite serious discussions there as things go forward. So I don't think it's so much separate guidance as continued emphasis in all the different bodies. And one thing I would just flag, of course, is as far as LPS is concerned, it's completely irrelevant that a local authority may have children's services or adult social care. It's a local authority responsible body. And so the local authorities I've seen who've been working best towards preparation are the ones where saying this is a joint team effort, as opposed to there's children and there's adults and the twain may meet. I don't know, Tim, whether you had anything you wanted to say in relation to 16, 17-year-olds.
No, just I mean the code the code does deal with them together, which I think is a very positive thing in the same chapter. There's a lot of interesting stuff, I think, around transitional arrangements, about thinking about where necessary, putting in place prospective arrangements before the person turns 16 and some of the challenges in those sorts of cases. But I agree with you, Alex, it's a really important point.
Yeah, and Helen has just put in the chat function, I mean, the fact that the guidance really kind of in a way just linking to what you're saying, and the guidance, the code could go a lot further in terms of thinking about how to support transition in terms of just, I think I've just summarised what she said. Yes, I think, Sophie, that the other questions are either slightly technical or more comments, as it were, given we've got 1 minute left. If you not wanted to not answer them, but they're probably either take us, down slight rabbit holes, possibly just for the broader audience.
Great. Okay. I think that we will pretty much wrap up there. And it's just to say a huge thank you for coming on and giving us a whistle-stop tour of your main best bits, if you like, of the changes and the consultation. And of course, we're going to be going into much more detail around some of the issues that you raised in a bit shortly. But just a huge thank you to both of you for coming on. We have put some links on how to reach out to your other material in the chat, and we'll send out an email to everybody as well. I know that, Tim, you said that we can share your slides as well. So anyone who signed up via the Eventbrite can get a copy of those, and we'll send those off shortly. So I know you two have got very busy days, so I'll just say goodbye to you, but do everyone else stay on to hear about what's coming next. But thank you very much, Tim and Alex. Okay, I'm just going to attempt again to put my slides up because that didn't quite work last time. So bear with me a second while I do that, because what we want to do is just talk about what's coming next. And it's going to be really replying to a lot of what people were saying, again, what we were talking about just earlier, and actually doing the whole responding to the consultation. I don't know if people can see my full slides there. I'm going to try. I'm thinking that I'm sharing my slides, but Bonnie, I can see you. Can you just thumbs up if you can also see my slides, like in a proper presentation format, not how I had it before? Great. Okay, thank you. So what we'll be doing shortly is going into breakout rooms, and Zoom is going to allocate different breakout rooms. And when we come back after this short break now, I'll go into more detail about what we're going to cover in the breakout rooms, what the questions will be. And we really want you to just kind of go into whichever breakout room you find yourself in and just either stay there and respond, or you will have an option to come out and join a different breakout room. And the whole idea is that we're going to have picked out different comments from the consultation. One of them will be looking at some of the scenarios, the examples that are in the Code of Practice, and seeing if those examples are akin to what you address in your everyday use of the Mental Capacity Act, whether there are other scenarios which you think would be helpful either within the Code of Practice or as a separate document, as Alex suggested, which I thought was a fantastic idea. So that's one of the topics. We'll also be covering some of the Section 4B. We'll also be looking at some of the smaller questions, which you might want to have a discussion about, but you might also just want to do a quick yes or no within your groups about whether you think the decision around the care managers, whether they should have responsibility, then that's been removed, and whether that was a good idea or not. So that will all be covered as well in the breakout rooms. Like I said, it'll be a random selection of people. Zoom just does it automatically. We'll spend a couple of minutes just making sure that there's somebody from our team just helping to field the discussions in each of the breakout rooms. And we'll help you with any issues. So I think for now, what we're going to do is just have a short comfort break of just over 5 minutes. And we are going to play a video, and as some of you who engage with our material in the past will know, we do these videos on YouTube anyway, and we talk to different organisations that are involved in social care. So Kurum, who you'll hear from in a second, is an organisation who looks at how people provide support differently. So it's a different commissioning model, if you like, and I've interviewed them and we've recorded that, and so they'll be sharing some of their experiences and who they are on that video. But it's not live, so you can just go and get yourself a drink, get some refreshments, meet us back here in about sort of just over 5 minutes time. I think we'll start kicking off just after past. Where I will run through the breakout rooms in a bit more detail, and then our team will try and sort of set it all up, because we want to record the breakout rooms, not to share it with anyone, but just so that we can have notes on what people say and what we need to put in our consultation response following this event. So hopefully that all makes sense. And if anybody does have any queries, then please do just put them in the chat. Of course, if you need to leave, that's absolutely fine. But if you do have time to stay on, even if it's a few of you, that would be really good, just to get your perspectives on what needs to change. And we've got lots of material to refer to, so you don't have to just think of it at the top of your head and sort of think, oh, what was in the guidance, or what was in the code or regulations. So I'm going to break off now. I'm going to stop sharing, and I think one of my team is going to start the video. And if you could meet us back here in about 7 minutes, or stay, of course, and watch the video in the background, and then we will start the breakout rooms and go from there.
Great. I'm just to start the video in a second. I'm just pulling it up now. We'll end the live stream after the video has played as well.
Hello everyone, and welcome to Coproduce Care's mini discussion that we're going to be having with an organisation called Currem. So I'm not going to spend too much time introducing them myself. I'm going to bring in one of their co-founders, Patrick Wallace, and let him talk all about Currem. Hello Patrick, how are you today?
Very good, thank you.
Wonderful. Thank you so much for coming on and talking to us about your wonderful organisation. So I'm just going to go straight in and ask you, what is Currem? Can you tell us all about what it is and what it does, first of all?
Well, we're a tech-enabled platform for carers, and it allows the carer and the client to match directly. And from that come a host of benefits, which we can get into later on, but primarily around increasing carer earnings. And that enables that. That's the fundamental of the business.
Brilliant. Okay, thank you. And can you give me a bit of an idea of what inspired you to set up Currem?
Well, I mean, I think it's universally agreed that what is often called the crisis in the care sector is fundamentally driven by low carer earnings. And everybody's identified that, from politicians to care sector leaders to carers. I mean, carers on the whole are fantastic people, and they have, it's a vocation for them. But unfortunately, they're earning £9.50, £10 an hour. Some of them are running a car on the back of that, which is how they do it. And these low earnings is the core problem. And in a typically British way, everybody identifies the problem and then ignores it. So we decided to do something about it. So that's what inspired us, which was to set the business up and to come up with a model whereby you do improve carers' pay significantly. And that's what we've done.
Brilliant. So really focusing on how can we give care workers a better deal with the working conditions and the pay that they have. So yeah, well in support of that. So it sounds a little bit like a care agency where people can get care workers to support them, but it's not a care agency. So can you explain a bit about that distinction and how it's different from a care agency?
Yes, I mean, there's always going to be a requirement for care agencies. They do a fantastic job, and the people in them do a fantastic job. But we're different in that if you look at the requirement, we need to pay, or carers need to earn £14, £15 an hour. Hospitality is paying £11 or £12 an hour. So is retail. Amazon are paying £13 an hour. That's why you have a sectoral churn of staff in the care sector of 30% per annum. It's unsustainable. You can't invest in training, you can't retain staff, the cost of acquiring them, completely unsustainable. So it's a very difficult job and with a lot of responsibility, and it needs to be paid well. So carers need to earn £14 or £15, which they do in our platform. But the the budgetary constraints that the care sector is under is the fact that councils have a budget of 17 or 18 pounds per hour, and the councils effectively fund over 50% of the care provided in the UK. So you have to come up with a model where councils can pay 18 pounds and the carer earns 15 pounds, which means that you have a margin in the middle of 3 pounds. And how we enable this to work is that we effectively remove a lot of administration. So what does that actually mean? Well, it means that the carer has to do a bit more. Our carers are self-employed. They provide their own invoices, they run their own schedules, and the client has to do more. The client has to choose their own carer, which is fundamentally a good thing in most people's opinions. Choice and control are central aspects of the Care Act, and they have to manage their carer. But again, not for everybody, but for a lot of people, that's a perfectly reasonable relationship. In fact, it reinforces the relationship between the two key parties, the carer and the person or their family. And we enable this with technology. So on our platform, yes, the carers are self-employed, but we provide them with free training, free insurance, sick pay, a host of benefits. As I said, but now over 100 free training courses are coming in this month, et cetera, et cetera. So, the model works. We've delivered over 1.5 million hours of care. We've had nearly 3,000, happy clients, and we're growing very quick.
Brilliant.
It's the model that works.
It sounds like a fantastic platform. And just very briefly, if you are somebody who's looking for a care worker and they want to use your platform, how do you safeguard clients and care workers in this system?
Well, we're pretty confident we have the best carer verification process in the UK. We use the same tech that Revolut and Monzo use, if you've ever had one of those bank cards. So carers have to take a selfie, and then they have to take a photo of their ID and their various certificates, and those are uploaded. Then we do a half-hour onboarding call, check all the documentation. Carers have 2 referees, and then it's down to the individuals to choose that person. And likewise with carers, we obviously take full details of clients. We ring the clients. We're also introducing similar identity checks on clients, and we are also launching a carer safety app or feature on our app. So we go as many lengths as you possibly can in an environment where people are lone working. We do our very best, but that's the same challenge that every agency or anybody has in a lone working environment.
Brilliant. Well, thank you so much, Patrick. That was really comprehensive and very interesting. And if more people want to find out about your organisation, we've provided lots of links along the bottom of the screen, and people can visit Coram as well on their website and social media. So thank you very much for joining us, Patrick.
Not at all. Thank you very much for having me.
I'm just going to end the live stream, everyone. That's the sort of live stream segment over, and I'll start the recording of the main